All right, let's talk a little bit about title insurance and deeds. Obviously, the two of these really kind of work together. You got to understand both of them, not only for exam purposes to get your real estate license, but I'm going to tell you, if you understand what we're about to go over right now in this little training session, I promise you, and well, let me further state, if you understand it, and you can explain it to clients, buyers and or sellers, especially sellers, as you'll see as we go through here, I don't think you'll ever have to worry about looking for business, because they're going to understand immediately that, look, you know what you're talking about, why this is so important, and then, look, they're going to refer so much business to you, it'll be crazy. So anyway, so what are we talking about here with title insurance and deeds? Well, first of all, let's talk about title insurance. Well, what is title insurance? And I will tell you, and if you look at this on the slide, it says it's acceptable evidence of marketable title. For those of you looking to take the state exam, I can almost guarantee you this will be a question they'll ask you. In fact, the question will probably be something along the lines, which of the following would be considered acceptable evidence of marketable title? And the answer I'm telling you they're going to be looking for is title insurance. So real quick, what is marketable title? Y'all, that's one of the things, you know, when the attorney does their title search, they'll come up with an abstract of title, but one of the things that they have to prove, actually two things the attorney is having to prove to the lender, that the seller actually has both good and marketable title. That's two different titles, both good and marketable. Good title just means I own it, or the person that's selling it actually owns the property. So if we can prove that they own the property, that's considered good title. But then we have to make sure that not only do they have good title, but they have marketable title. Marketable title means that they can actually sell it, give it away, or convey it to someone else by whatever means. A lot of people may have good title, meaning they own it, but for some reason they cannot convey it, cannot sell it, can't give it away, can't do anything with it. Yeah, I'm not going to get into all that. That'd be another video. But just because somebody owns the property does not necessarily mean they can legally transfer it or convey it to somebody else. If they can, then that's considered marketable title. So that's what the attorney is trying to prove when they do their title search. This seller has, they have good title and they have marketable title. Well, there's about three different forms of proof when it comes to acceptable title, or excuse me, a marketable title. But the one, and the primary one, I'm telling you, is the title insurance. And that's the one we're going to be looking at right now. We need to talk about that. But you need to remember, title insurance is acceptable evidence of marketable title, that the seller can convey the property. Well, when it comes to title insurance, what does it do? Well, I will tell you, it's insurance. It's kind of like any other insurance. You know, why do you have car insurance? To cover you for, in case you wreck or something of that nature. Yeah, it's going to cover you for damages, losses, things of that nature. Title insurance is no different. You know, could you potentially, in fact, let me put it this way. Put it in layman's terms. It's the only way I know how to do it anyway. But, you know, let's say you own your house. You've owned it for 20, 30, 40 years, however long. In fact, it might even be paid for by now. But is it possible that at some point somebody could come and knock on your front door, you answer the door, and the person standing there says, you're in my house and you need to get out? Could that happen? Yeah. Yeah. Not only can it happen, it does happen. It's unfortunate, but it happens. Now, let me just tell you, if that should happen to you, you're leaving. You're out of here. You've lost that house. It's not yours anymore. We'll talk about how these things can happen here in a second, but just understand, y'all, it happens. Now the question is, now that you've been basically thrown out of the house, thrown off the property, what about the money you paid for the house? What about all the investment you've made into this property? Do you get that back? And the answer to that question is, did you have title insurance? That's what title insurance is for. It covers title defects, liens that may be put on the property that nobody knew about at the time of closing, when you purchased the house. Look, there's all kind of things that could have taken place with this property that was never recorded or made public. And if it's not recorded or made public, then you may not ever even know about it. But it doesn't change the fact that something took place at some point in the past, and it is what it is. It doesn't just go away. It happened, but you didn't know about it. But anyway, that's what the title insurance is for. Let me give you an example of how these kind of issues can really take place. I actually had a cousin. Now this is a little while, several years ago now, I guess. But anyway, I had a cousin. He's probably, at the time of this event that I'm telling you about, he was probably in his 50s, maybe 55, something like that. But when he was just a baby, and I'm talking about like a year old, his grandfather died. And when his grandfather died, he left his house to, which was his grandson, it was my cousin. Now, obviously, there's not a whole lot a one-year-old can do with a house, right? So when you do stuff like this, you have to set it up in a trust. That's where that deed of trust might come into play. And when you have a trust, then you got to name or have a trustee, someone that will take care of it, do whatever needs to be done, but just take care of the property until my cousin became 18 or of legal age, and then it would become his, and then he'll deal with it. Okay? Well, the person named as the trustee was actually my cousin's dad. He was the trustee of this property. Now, the sad thing about all of this, my cousin never knew about this house. Never knew about it until he was in his early to mid 50s. I mean, we're talking about 50 years later. And the only reason he found out about it at that point is because his dad actually passed away. And when his dad died, he was in his house, packing stuff up, cleaning stuff out. And he happened to go up in the attic and was pulling stuff out of the attic. And he found an old lock box. Had some papers in it. Obviously, he didn't have a clue what it was or if it was any good. But he did make the right decision. He took the lock box to the attorney and just asked him, is there anything in here that's any good, or is it just trash? Do I throw it away or whatever? Well, in that lock box is where he found the deed, where his grandfather 50 years ago had left this house to him. Unfortunately, my cousin's also learning at this point, at the same time he's trying to bury his dad, that his dad stole this house from him. He was, I don't know exactly how he did it, but apparently he was able to forge some documents, which in itself obviously is illegal. But he had these forged documents recorded into the public record that indicated that he actually owned the house himself and not as the trustee. He actually now owns it himself. Well, once he was able to get the record, the public record, to reflect that he was the actual owner, then he sold the house. Now, what he did with the money, nobody knows, okay? But basically, the attorney told him, because what your dad did was illegal. If you want this house, it's still yours. Basically, all you have to do is claim it. And my cousin said, well, if it's mine, then I want it. Well, the people that were currently living in that house, they got that knock at their front door telling them, you're in my house and you got to go. Now, look, what's the chances that when these people bought that house, that they had any idea they were buying it illegally. They had no idea. None. And that's the issue you'll have occasionally with real estate. You never know what took place or what happened with this property prior to your ownership. That could come back and affect you at some point in the future. That's why you have title insurance, to protect you against these losses and defects in title and issues like this. In fact, I will tell you that house, that particular house, it had actually been sold. I think he told me it was sold like 5 times since it was sold illegally. So there was 5 other people that bought that property illegally. Again, they didn't know it, but it doesn't change. Just because you didn't know it does not change the fact you shouldn't have made that purchase, because it was an illegal purchase. So that's why you could potentially lose the property. So again, this is why we have title insurance, to protect against those types of things. Now, when it comes to title insurance, as you see here, there's actually 2 types of policies. There's 2 policies. There's the lender's policy, or what we might call the mortgagee's policy, and then there's an owner's policy. In fact, I'll tell you, if you're borrowing money from the bank to make the purchase, you got to borrow the money, you will buy a lender's policy. That's not something that's typically discussed, not even something brought up. It's just part of your closing cost. So you will buy a lender's policy. Now, the owner's policy, which would cover the purchaser, that policy is totally optional. So technically, you can't be forced to buy that. And quite frankly, you shouldn't even be sold that policy if you did not ask for it. Because the assumption is if you didn't ask for it, then you must not have wanted it, right? Now, hopefully, if you got a good attorney that's closing it, they'll talk to you about this kind of stuff. But I'm telling you, not all of them do. And if you don't ask for title insurance, the owner's policy, then you may not get it. But here's the difference. If you have the lender's policy, the mortgagee's policy, and let's say something like this happens to you where you're asked to leave or you're kicked out of the house, the lender's policy will at least pay off the unpaid balance. So whatever you still owe on the property will be paid off by this title insurance. So at least you're not out of the house and still making payments on something you don't even own. The problem is, what about the money you've already paid into it? What about all your equity in that property? Do you get that back? Well, you'll only get that back if you also purchased an owner's policy. So you really need to buy 2 policies anytime you buy real estate. The lender's policy and an owner's policy. Now, we already talked about this marketable title a little bit, but here on this slide, you see we're really dealing with the difference between marketable title versus insurable title. Remember, we said marketable title just indicates that you do own the property and you can transfer it or convey it to someone else, sell it, if you will. Insurable title means it is insurable. The insurance company is comfortable, based on what we've been able to find out in the public records, that title is clear, shouldn't have a problem. It doesn't mean you won't have a problem. It just means that the risk is greatly reduced, I guess. But so anyway, the insurance company is willing to insure title to the property. That's all they're talking about there. Now, how much does this title insurance cost? Well, I will tell you that's going to vary, so there's no way I can sit here and tell you how much title insurance costs. But the cost of it is based on the value of the property. So obviously, the more valuable, the more money at stake, the more it's going to cost. But I will tell you, it's not very much. It's a very reasonable, at least in my opinion, it's a very reasonable cost. Now, the good news is it's just a one-time payment. Obviously, you pay it at closing. It's part of your closing cost. But again, it's a one-time payment. So it's not like something you're going to get a bill for every month or every year or something like that. You pay it to one time and then you're covered. That's it. Now, how long does that title insurance last? How long is it good for? Y'all, I'm telling you, I hear a lot of insurance agents, they get this wrong. In fact, a lot of people say, well, it's good for as long as you own the property. That's not true. Title insurance will cover you for as long as you and your heirs are still alive. That's a good thing. Y'all, you'll see a little bit further into this module here why that's so important. Y'all, in fact, let me just go ahead and say this much right now. You know, I've had people say, you know what, I'm not sure that I had title insurance, or maybe I know I didn't have title insurance, but I've already sold that property. I don't own it anymore. It's not my problem. So if something happens, not my problem. Oh, well, hold on a second. Go back to that example I was telling about my cousin. And we said it was sold 5 times illegally. You know, the people that were currently living in the house and got kicked out of the house, what do you think they did? Do you think they took any legal action when they were basically kicked out of their house? I guarantee you they did. And what action did they take? My guess is they turned around and sued whoever sold it to them illegally. Even though they don't own it no more, you sold it to me illegally. And by the way, and then when that person gets sued, what do you think they did? They turned around and sued the person that sold it to them. Y'all, so look, you've got what we also call a chain of title, which lists all the owners or anybody that ever owned interest in the property is in that chain of title. So if you ever owned real estate, you're on that chain of title. Now, just because you don't own it today, you sold it years ago, y'all, does not mean a lawsuit can't come your way at some point in the future. Even though you don't own it. And you're going to say, but I haven't owned that property in 30 years. Okay, but you're still on the chain of title. And you took part of conveying the property illegally. Again, not that you knew about it, but you did. Well, guess what? You're still covered under the title insurance. And by the way, not only will it cover you for loss or damage, it'll cover your legal fees. And I'm telling you, this is a huge insurance policy to have if something should ever happen, especially for a one-time payment. That's some pretty good insurance right there. And that's why you'd be covered for as long as you're alive, not just while you own it. Okay, so now that you understand what title insurance is for, why is this a big deal when it comes to deeds? So why am I talking about title insurance and deeds? Well, now let's talk real quick about deeds. Now, first of all, what is a deed? That's the legal document that actually conveys ownership rights to someone else, to the buyer. Okay. So, you know, and they could ask you about this on the exam. You know, what is a deed? It's a conveyancing document. It conveys property from one owner to another. That's all it is. Deed just conveys ownership rights from one to another. That's what the deed is. And, you know, just because it's kind of fun to me, you know, especially when I'm teaching a live class, you know, I'll ask the students in the class, when you bought the house you currently own, or maybe you've recently sold a house, if you sold the house, what kind of deed was used? And people look at me, give me a strange look like, what do you mean, what kind of deed? A deed's a deed. Well, no, it's not. There are several different types of deeds, and we're going to look at a few of them right here, or at least the ones that they would likely or could likely ask you about on the exam. We're going to talk about them real quick. But y'all, there are different types of deeds. So what's the difference between one deed and another deed? Well, the first thing I wanted to make sure you understand, all deeds do the same thing. No matter what deed you use, the purpose of that deed is to convey the ownership rights from the seller to the buyer. That's it. Bottom line, period. Any deed will convey those rights. Now, so what's the difference? The difference, basically, depending on the type of deed you use, determines the extent of guarantees and warranties the seller is making to the buyer when it comes to potential defects in title. Okay? Some deeds offer extreme guarantees and warranties. Some offer none. And so let's take a look real quick at some of the, in fact, I think I've got 5 different deeds that you need to be familiar with for exam purposes. But we're going to look at these 5 types of deeds. Now let me say too, the first 2 here that we're getting ready to talk about are the primary or most common deeds used in your typical buying and selling of real estate. It could be one of the first 2 that we're going to talk about. Okay. Again, we could use all 5 that we're going to talk about, but the primary, the one you're going to see most often, is either one of the first 2. Well, the first one we look at is this general warranty deed. And basically, in fact, it says seller makes unlimited and timeless, meaning things that could take place in the future, guarantees and warranties against title defect. So in other words, if I'm selling my house and I convey these rights to the buyer and we use a general warranty deed, basically what I'm telling the buyer is this: buyer, if any defect in title should ever arise that took place while I own the property or even before I own the property, I'm responsible. I totally 100% guarantee and warranty against any kind of defect in title. Y'all, that's a lot of guarantees and warranties you're making right there if you're the seller. No doubt about it. But the second type of deed is the special warranty deed, or a lot of times you'll hear even attorneys refer to it as a limited warranty deed. But if we use this deed to sell or convey the property, now what I'm saying, if I'm the seller, what I'm telling the buyer is this: buyer, I guarantee you that nobody else gained any interest in this property while I owned the property. But I'm not guaranteeing anything that could have taken place prior to my ownership, because who knows what could have happened prior to my ownership. So really, all I'm guaranteeing is that there's no defect in title that arose or would come up during the time that I owned it. Nothing before. So that's why they call it a limited warranty deed, or I think the legal name is special warranty deed. So special warranty and or general warranty, y'all, those are the 2 deeds that you tend to see most common when you're buying and selling real estate. So then here's the question I would have about these 2. If you're selling your house, which one of these deeds would you prefer to use? And my guess is you're going to say the special warranty, because it's my liability here is limited to just during the time that I owned it. But what about if you're the buyer? If you're the one buying the property, which deed would you prefer? And my guess is you say, well, I want the general warranty. I want all the guarantees and warranties I can get. I want the general warranty deed. So then here's the question. So then which one are you going to use? You got the seller preferring one, the buyer prefers something else. Which one are you going to use? And you're probably thinking, if you've ever bought or sold real estate before, this has never been an issue for me. I bought houses before. I sold houses before. And this topic this discussion has never even taken place. We've never even talked about this. And there's a reason for it. Because in the contract of sale, that apparently a lot of people don't read, and when they do read it, they'll read things that they don't understand and know what it means, so they just continue on, don't worry about it. But it's already pre-printed in the contract of sale which type of deed you're going to use. It's already there. So it's not something that we discuss. It's not a fill in the blank. It's not a question you're having to answer. The contract of sale typically states already what deed will be used. So we never question it. We never discuss it. We just sign here and go to closing and hope everything works out well. Y'all, that's not what a good real estate agent should do. Y'all, we need to talk about this kind of stuff. Now, I will tell you, not every contract of sale says the same thing. Some contracts of sale stipulate a general warranty deed. Some stipulate a special warranty deed. So you need to pay attention to those kind of things. But I will tell you, at least in the local contract that we tend to use here locally, and again, wherever you are, you need to read these contracts of sales and see what it says in the contract. But here, our standard contract, it says that the property will be conveyed using a general warranty deed. Why is that a big deal? Why does that matter? Why is it so important? Well, I will tell you, before, if I'm representing the seller, before I'm going to allow my seller, I say allow, we're going to talk to them. I'm going to say, look, this may not be a very good idea for you to do this, seller. But before I can go any further, here's the first question I have for my seller. Seller, when you bought this property, however long ago it was, when you bought it, did you buy title insurance? Now, and I hear people, a lot of times they'll say, I'm not even sure. Don't even know what it is, quite frankly. Don't know. Then I'll have some people, yeah, I'm sure we did. In fact, I think it's required, isn't it? You hear all kind of answers. At the end of the day, if I'm going to provide the best representation I can to the seller, I need to know, did you buy title insurance? I don't want to guess. I don't want to make assumptions. I need to know. Well, so how do we know for sure? Well, really, there's a couple different ways. One, obviously, if you have a copy of the title insurance policy, that's pretty clear evidence you have title insurance. I will tell you, in my 20 plus years of doing real estate, I've only had one client, that actually had and knew where that policy was. He had the policy. Most people don't have it, don't know what happened to it if they ever had it. But the other way I could know is I need to see the settlement statement when you actually purchase the property. Because on the settlement statement, if you bought title insurance, it'll show it on there. The settlement statement's got to show all monies that were bought, or any debits, any credits from buyer and or seller that took place for this transaction. So when I look on that settlement statement, sure enough, I see, yep, there's a line there that says he paid X amount of money for title insurance. The problem here that you got to be careful of, if you just see one line where he bought title insurance, then seller, that means you're not covered. You don't have title insurance. Because remember we said there's two types of policies. There's a lender policy and an owner's policy. So guess what, if you only got that one line indicating one policy, guess what policy you bought? The lender's policy. So the owner's not covered. So what I'm hoping to see is two lines indicating he bought two policies, right? And I will tell you, the owner's policy is not nearly as much as the lender's policy. Not that either one of them are that expensive, honestly. But the owner's policy is just really a few dollars more to get the owner's policy. So it's crazy not to go ahead and get that owner's policy, but you got to ask for it a lot of times. Okay, now, but here's where I'm going with all this. If I know the seller has an owner's title insurance policy, then quite frankly, it does not matter which one of these deeds we use. We can go with the general warranty deed, which makes all these guarantees and warranties, because I know the seller is covered against all defects, all losses, all kind of issues. They're covered. They're insured for it if something should happen. But if I find out, or I can't prove the seller has title insurance, an owner's policy, then guess what? We're going to change the contract. I'm going to take the general warranty deed out of the contract and then put in special warranty deed, which limits the liability for my seller if something should ever happen in the future, right? I'm telling you, this is the kind of stuff, if you do this for your clients, they're going to appreciate and understand why they're paying you whatever you charge them. They understand it. I got an agent and they got it. They're protecting my interest. So you don't have to worry about finding business when you have clients that feel that comfortable about you at that point. So anyway, that's the general and special warranty deed. And then real quick, these other deeds. This next one you see here is a quitclaim deed. You see this used a lot. It's a very common deed. But it's not common when you're buying and or selling real estate. You don't typically, you wouldn't use it for that purpose. But again, like I said, all deeds do the same thing. They convey ownership rights from one person to another. Well, with a quitclaim deed, a lot of time, most time, you're just, someone is saying, you know what, if I own interest in this property, you can have it. You can have it. Where you might see this a lot, and might be a kind of unfortunate instance, but where you see it a lot is in cases of a divorce, where say the wife actually owned this house, it's in her name, and she owned it prior to getting married. Again, it's in her name. She's been paying, making the payments and stuff. But then she gets married. They married for 5 years or whatever. At that point, could the husband claim ownership interest in the house? Even though his name is not on the title, not on the loan, could he possibly have? He could. I'm not going to get into all the legal ramifications of that. We ain't going there. So what a lot of times they will do, or what the attorneys will ask them to do when they get a divorce, husband, you go your own way. They'll ask the husband to sign a quitclaim deed, which is basically saying, what he's saying here is, if I own any interest, which I'm not saying I do, not saying I don't, but if I own any interest in this property, you can have it. Talking about back to the wife or the person who's getting ready to divorce. It's all yours. I give up any rights, any interest to this property, but I make no guarantees and no warranties against defect in title. And that's the key there. A quitclaim deed makes no guarantees and no warranties when it comes to defects in title. In fact, if they ask you, and they could ask you on the exam, could very well ask you, which of the following deeds would carry no guarantees or warranties expressed or implied of any kind? The answer, I guarantee you they're going to be looking for is quitclaim. The quitclaim deed. All right. And then there's the tax deed. A tax deed is, if you ever go to a tax sale, if the county basically forecloses or takes property because the owner has not paid their property taxes, occasionally they'll have a tax sale, and for anybody coming in will pay off these taxes, they get the property. Well, how do you get the property if you happen to be the person with the higher bid? They'll convey the rights via a tax deed. I will tell you, there's some other things. If you ever get inside to do something like this, you need to dig a little deeper. Okay, I will tell you, you need to dig a lot deeper, because with the tax deed, and I'm not going to get into this, but with a tax deed, could you just go out and now sell the property to somebody else? No, not with a tax deed. There are other issues with it. You will have to clear the title. I'm just going to leave it at that. I don't want to get off onto a tangent here, but I will just warn you, don't go buy or bidding on properties at a tax sale if you don't know what you're getting into, because you can't just turn around and sell it. There's a lot of other things that would have to take place. But anyway, tax deed is what you would get when you purchase or bid on property at a tax sale from the county. We'll just leave it at that. I will say this too about a tax deed, because we were talking about title insurance. A title insurance company, or at least none that I've ever talked to, so I don't say it never happens, but I'm going to tell you it would be extremely rare if you can get title insurance on a property you bought at a tax sale. So right there, that tells you the insurance company considers this to be a very risky transaction. So just beware of that you're probably not going to be able to get title insurance on anything you purchased at a tax sale. So just keep that in mind. And then the last deed is a trustee's deed. We kind of touched on that a little bit with my cousin's example. Remember, his father was the trustee. He was holding this property for my cousin in trust. Y'all, that's a trustee's deed. So, you know, if I've got a property that I'm holding for my son, which is not 18 yet, that I'm holding in trust, so I will be the trustee. So they will basically issue a trustee's deed to me, showing that it's my property to maintain and take care of on behalf of someone else, you know, for some period of time. That's all a trustee's deed is. And then the last thing I just wanted to touch on real quick are these characteristics of a deed. Y'all, there's 2 or 3 things right here in this little section they will likely ask you about on the exam. So I wanted to cover this too. Remember, we said all deeds do the exact same thing, convey property from one to another. So, y'all, so the information for the most part is the same. Y'all, all deeds look almost the same. Y'all, they all have the same information in the deed. Again, the only difference from one to the other is the extent of guarantees and warranties you're making, right? So what kind of information would you find in a deed? Well, the first paragraph of the deed is what we call the premises paragraph. And you see listed here the things or information you would find in that paragraph. Obviously, both the names of the grantor and the grantee will be there. Any facts that are relevant that need to be presented will be in this paragraph. But then this third bullet, y'all, this granting clause, y'all, this is one that you might want to pay attention to, certainly for test purposes. There has to be a granting clause in the deed, and this is where it will be. Now, what's a granting clause? It's some words that express conveyance. In other words, if I'm selling my house to John, it will basically say in the deed, I, Frankie Griffin, hereby convey all rights and interests to John. Y'all, that's considered a granting clause, where I've granted all my ownership rights over to John. That's what a granting clause is. It's just words that express conveyance from one to another. And then the consideration, whatever the consideration is, has to be there. Remember, consideration can be valuable or invaluable. Valuable would be the price paid. So if they paid $200,000 for the house, you'll see it in the deed. Here's how much the buyer, the current owner, this is how much he paid for the house or paid for the property. But if you're just giving it away, then there has to be invaluable consideration, which is what we call love and affection. So it will say in the deed that this property was conveyed for love and affection, meaning no money's passed hands. And then obviously you got to have an adequate description of the property. Y'all, description is talking about like a legal description, tax map number, that kind of stuff. Y'all, the next paragraph is the habendum paragraph. Y'all, they could ask you what is habendum? Habendum just means the right to have and to hold. That's it. So what are we looking at in this paragraph dealing with the right to have and to hold the property? Well, this is where it will describe the type of estate. If you've taken the real estate course, hopefully you remember there's different types of estates, right? There's defeasible fee estates, there's fee simple estate, and so forth. But it'll also say, any conditions affecting, they're talking about restrictions. If this is a defeasible fee estate, remember, defeasible fee means there are restrictions. Where yes, I'm selling it to you as long as you promise not to do this or promise you must do that. But there are conditions or restrictions that the buyer must honor. If you violate those restrictions, you're going to lose the property, right? Well, this is where you find out what those restrictions, if there are any restrictions, this is where you're going to find them in this paragraph. This is it, the habendum paragraph. And then the next paragraph is the testimonium paragraph. Y'all, this is where you find the date of conveyance. This is where you're going to also see or must have what they call a competent grantor's signature. Now, who's the grantor? That's the seller. Grantee would be the buyer. Well, wait a minute. What about how come it doesn't say anything about the buyer's signature? Y'all, the buyer does not sign the deed. Only the seller signs the deed. There's no place for the buyer to sign, nor any reason for them to sign. Because when that seller signs the deed, y'all remember we talked about the granting clause back up in the first paragraph? So if I'm the seller and I sign this deed, that granting clause said, I, Frankie Griffin, hereby convey all my interest to John. I've now given it to John. And remember, we listed what the consideration would be, what the money would be. You got to pay me what we agreed to, and then I'll convey these rights to you. So really, all the buyer has to do is just accept it. Yep, I'll accept this property. And that's all they're doing there. And then lastly, when it comes to recording the deed, y'all, there's 3 types of notices, and I'm telling you, they like to ask about these on the exam. So the first is talking about constructive notice. Y'all, constructive notice just means you have recorded the transaction, you've recorded the deed in the public record. You've now given notice to the public. This is now my property, not yours, stay away. Y'all, that's constructive notice. It's recorded in the public record. But then there's what we call actual notice. And y'all, and I'm going to tell you, this is something a lot of people don't realize, apparently, based on people I've talked to. Y'all, when you buy a house or sell the house, but primarily when you buy the house, do you have to record the deed in the public record for the transaction to be valid? No. It does not have to be recorded. And if it's not recorded, that's what we call actual notice. You know, it says here, actual notice is not recorded in the public record, even though it's still valid and is still legal. So you can still own it. It is yours. It is rightfully and legally yours. The problem is nobody else knows it because you never recorded it. Y'all, this could present problems down the road for you if you're not careful, if you choose not to record it. Talk a little bit more about that in a second. But then this third notice is a little bit different than these first 2, called inquiry notice. Y'all, obviously, if you ever have to sign a legal document, would it be a good idea to make sure you know what you're signing before you sign it? Yes. And that's what this is saying here. Y'all, inquiry notice basically says this. If you're not sure what you're signing or what it means, it is your obligation before you sign it. You must inquire into it. Look into it. Make sure you understand what you're signing before you sign it. Because y'all, once you've signed it, you can't come back later and say, but I didn't understand that. I didn't know that's what that meant. Too late. You had inquiry notice and you didn't take advantage of it. You did not look into it before you signed it. You got to live with it now. And then why is it important to record it in the deed? We were just sort of talking about that a little bit. But you know, if you look at that second bullet, it says in order to be covered, to protect yourself from future claims on the title, you should record the deed. Y'all, that's a question they could possibly ask you. Why should a buyer record the deed in the public record? To protect themselves from future claims on the title. There's the answer they're going to be looking for. All right, so y'all, there's a little information about title insurance and deeds. Hopefully that makes sense, clears up some things that might have been a concern to you. Look forward to seeing you on the next video. God bless.